right, before we do anything, I just want to start the recording.
Are you ready? There we go. Okay, I will call the November 13th Select Board meeting to order at 11 a.m. We're meeting via Zoom, consistent with the governor's allowances. And we will be taking all of our votes today via roll call. Let me just make sure that all board members are present and other people anticipated on the agenda are present and can hear me. I'm doing this off of memory. Tom Dixon.
Present.
Matt Fee.
Here.
Okay, Don Holgate here.
And should we just note that Dr. McNabb will not be joining the meeting?
Yes, I know that that Malcolm McNabb will not be joining today, and Brooke Moore should be on, but she has to leave by noon. Amy Baxter, can you hear me?
Yes. Yes.
Okay, good morning. I know Erica can hear me. Brian Swain.
Here, I can hear you.
Hi. Lieutenant Mack.
Hi, present.
Hi. Michael O'Reilly, and I see Jim Meerberg on the screen as well.
Right, we're both in the same location. Thank you.
Good morning. Okay, if everyone's all right, we can get started. I don't believe there are any changes to the agenda. First up, we have licensing and petitions, request for approval of application for pledge of a seasonal all alcoholic beverage in-holder license to Nantucket Island Management LLC, DBA Brant Point Grill, White Elephant, for premises located at 50 Easton Street.
Okay. Thank you so much.
Before we start, Don, I normally would recuse from this. I sell them a little bit of drinks. Since there's only two of us, I'm disclosing it. It's not going to impact my ability to do the right thing. So I'm going to participate. Thank you.
Thank you, Matt. And let me just note that Brian Riley from Town Council has joined us.
Yes.
Go ahead.
Hello.
Thank you. And just quickly, thank you all for your time. I know this is extra time and you have very little to spare. We appreciate it very much, the focus on these businesses, and we'll hope to make efficient use of your time. So thank you very much. The first two that we are dealing with, it's the same application for both businesses working under Nantucket Island Management. So this explanation I'll just say once. For what a pledge is. We haven't done many of these, but in Massachusetts, the holder of a liquor license can pledge his or her license to secure a loan. There are several legal requirements that they must be aware of in compliance, which these applications are. The law states that any license granted under the provision of this chapter may be pledged for a loan, provided approval of such a loan and pledge is given by the local licensing authority, the board, and the commission ABCC. So as you mentioned, the first application here is for Nantucket Island Management LLC, DBA Brant Point Grill. Their attorney is here present, Brian Swain. This pledge is for liquor license for the loan that is stated here, and all the requirements for the pledge of this liquor license have been received and approved. So any questions for that? Good.
Any board questions? Brian Swain, is there anything you wanted to say? It looks like this will apply to the next one as well.
No, I think Amy did a great job explaining it. Thank you.
Okay, is there a motion?
It seems straightforward. I'll make a motion to approve.
Second.
Okay, all those in favor by roll call, and I'll note that Brooke Moore just joined us, but we'll take the vote without her. Matt Fee.
Aye.
Tom Dixon.
Aye.
Don Holgate, aye. And Brooke, we're just moving on to number 2. Okay.
Great.
Amy.
Yep. And so as I mentioned, the explanation for a pledge of a license applies to this as well. It is the same LLC, Nantucket Island Management LLC, DBA the Wawinnet Inn for the premises at 120 Wawinnet Road, pledging that license, seasonal all alcoholic beverages in-holder license, to secure a loan with the same requirements. And again, the license is in good standing.
Brooke, do you have any questions on this or other board members?
I don't. It seems straightforward. I would move approval.
I'll second.
Okay, all those in favor by roll call, Tom Dixon,
Aye.
Matt Fee,
Aye.
Brooke Moore,
Aye.
John Holgate, aye. That carries unanimously 4-0. Number 3, request for approval of application for a change of hours for an annual wine and malt beverage license at Annapurna Restaurants LLC, doing business as Sophie Teas for premises located at 8A Bayberry Court, to extend their liquor service from 9 p.m. to 11 p.m. Amy?
Thank you. Yes, thank you. So I did categorize this as a change of hours, which is an application that's an administrative application, doesn't require fees or ABCC review, to set this license straight, in that it wasn't, I didn't catch this correctly, as it was applied for in November of 2022. It was approved by the ABCC in 2023. At the time for the hearing, it was discussed that the prior owners of the location closed at 9 p.m., 9:30 p.m., and that there was concern that the change would affect the neighbors, as it's in a tight community there with residences as well. What I wanted to update, and this may affect others as well, is that there is a statutory requirement that they be allowed to serve any liquor license categorized as a Section 12 from 11 a.m. to 11 p.m. I put in here, as far as the ABCC, as a local licensing authorities, do you set the hours which restaurants can serve alcoholic beverages on weekdays? And it's to a limit. The Massachusetts state law says that the Section 12 licensees, that's on-premise licensees, cannot be barred from serving alcohol between 11 a.m. and 11 p.m. You may grant extended opening hours between 8 a.m. and 11 a.m. and extended closing hours between 11 p.m. and 2 a.m. So this is an effort to write that and set the closing hours for that liquor service at 11 p.m. I also included the special permit for Bayberry Commons there does allow for service no earlier than 11 a.m. and shall close no later than 11 p.m. So their special permit already sets those hours. So in essence, we should not have made that restriction and are unable to do so. So this is to bring that right up from 11 a.m. to 11 p.m. If I may, with Brian Riley here, I think it's a question I didn't ask, but if this affects others that I know that we have put conditions on for earlier closure of liquor service, can the town put conditions on a license such as no outdoor liquor service after 10 p.m.? Can they make that as long as service is allowed interior till 11 p.m.?
I would say, although I don't recall seeing that specifically, that I think, I don't think the ABCC would object to that. It's
Yeah.
just if somebody, you can't force them to close at 10 p.m. entirely if they want to stay open till 11. But
Okay.
I think as long as, they're still able to sell customers somewhere, seems to me
Yeah.
that would be a legitimate condition.
I'm thinking ahead to some other things this may apply to.
I think of 2 off the top of my head in town that we
Yes.
just restricted to 9 p.m.
Yes. So we may revisit this in December. It's something that's been kind of rolling around in my head because I know the applicants wanted to stay open to 11, and then I realized that this was something we couldn't really play around with. So it was my first mission to set this straight. So the vote would be to set the hours of alcohol service at DBA Sophie Teas from 11 a.m. to 11 p.m. in line with the liquor laws and as well with their special permit. If there's any questions.
Any questions from the board? Matt?
I have a question, Amy. Is the outside along the building, is that licensed now, or the other side licensed?
No, it's interior service.
Okay, so they'll
yeah.
have to come back to us. If they wanted to do outside seating, they're gonna have to come back anyway for an expansion of their, okay. But,
Yeah.
and I
I don't
think,
think that's not what she was asking for. that
No,
question for.
I
They're
understand
not
that. I'm just looking ahead and asking, because I
Yeah.
think, I don't think we should be going to 11 in some of these other areas, and we should be, and I'm glad we can make some differences between patios and outside and inside. And I
Yeah.
was just looking ahead. Thanks.
Yeah, thank you.
I don't see a problem. I'll move approval of this if,
Okay.
Second.
Is there any further discussion? Okay, all those in favor by roll call, Tom Dixon,
Aye.
Matt Fee,
aye.
Brooke Moore.
Aye.
John Holgate, aye. That carries unanimously 4-0. Next up, we have public hearings. The first one, as noted, has been withdrawn. Number 2, public hearing to consider application for alteration of premises of seasonal all alcoholic beverage license for Lemon Press, located at 41 Main Street, to remove the prep kitchen on the second floor from the license. Request for determination that the premise license to sell alcoholic beverages is not detrimental to the spiritual activities of a church.
Thank you. So as you mentioned, in this alteration, they're removing the second floor prep kitchen. The reasoning for this is they are applying for a 12C caterers liquor license, which we have several on island now, which is a good thing for private events and other things. It allows for them as a caterer to sell and serve liquor at private events. I included in the background discussion, just for background information, the requirements of a caterer's liquor license, which is state issued. When used, they do need to report to the chief of police through licensing. We have a report form for that. So the ABCC requested that this space be taken off so that they can properly store this alcohol. It needs to be separate from the license for their on-premise liquor license. So that is the reason for this request, so that final application can go through. Again, Brian Swain, as their attorney, is on for any questions.
Does anybody have it? Brooke?
Are they physically removing the kitchen or just removing it from the license?
Removing it from the license.
Okay, I was just curious. It's, yeah, we have a shortage of commercial kitchens on Nantucket. It would be a shame to have one removed. That was my only curiosity. It doesn't affect my opinion on this, but I was just curious.
Yeah, it's a second one. Obviously, their main kitchen, where they prepare for the restaurant, it was requested by the ABCC this be done for that.
Any other questions from the board? This is a public hearing. If anyone here is wishing to speak on this. I'm not seeing anyone. Does someone want to make a motion to close the public hearing?
So moved.
Second.
Second. All those in favor by roll call, Tom Dixon.
Aye.
Brooke Moore.
Aye.
Matt Fee.
Aye.
John Holgate, aye. That carries unanimously. Is there a motion to approve this? With the determination that it's not detrimental to the spiritual activities of the churches in the vicinity.
So moved.
Is there a second? All those in favor by roll call, Brooke Moore.
Aye.
Tom Dixon.
Aye.
Matt Fee.
Aye.
John Holgate, aye. That carries unanimously. Number 3, public hearing to consider application for a new common victualler with annual all alcoholic beverage restaurant license for Casa Real Restaurant and Bar. This is at 5 Macy's Lane.
Thank you. So as you mentioned, this is an application for a new liquor license, common vicular, and entertainment license at these premises. We're going to start with some background here. Obviously, as there's questions, as a liquor license was renewed at this address and these premises in December or November of last year for this year. So what has happened, and I've discussed this with Brian Riley, is here too as well to advise me if I misspeak on this. This has been kind of going on for a bit, the past couple of years, some issues with this license. It was renewed after we kind of chased them down last year, and it was renewed. It was never issued. We kept going back and forth, finally got an update somewhat in late winter that there was a sale of the property. And there began a bit of a back and forth with whether there was a valid lease still for the former tenant DBA, the Salt Box. We understood there to be an eviction in process and some legal activities when we were finally contacted by them, I think in April or May, as a town, said that we cannot conduct any inspections without a right to occupy. We did not feel that we received anything. We received old copies of leases that weren't signed and asked for some sort of notarized statement from the property owners and such. That was never received, and I've since not heard from the former licensee since May 17th. And so the discussion here is for you to be able to move forward. We are now in renewal period for these licenses. And what we're going to ask as we go through this application is these folks that are applying for this liquor license are the property owners. Again, their attorney, Brian Swain, is here as well. I'll give him an opportunity to speak. As well is that any approval that's considered for these licenses, it is new licenses so that they're not attached to anything pre-existing, that they be determined on their own merit, for the own applicant's merit, and that they be done on condition of any approval considered is done on condition of non-renewal of the Salt Box license, which we will do at the end of the month in the next meeting. Okay, so I'll revisit that as we get there. And we will just discuss the application itself. And then I will come back and discuss conditions and how a motion would be. Okay, if that makes sense with everyone. Brian, Mr. Riley, am I okay so far?
Yes, yeah, I would just add that since the existing license is in the name of the Salt Box or whatever their corporate name is, only the ownership of the Salt Box or the manager of the Salt Box has authority to sign off on a renewal application. So if this business really isn't a going concern anymore, presumably you're not going to get a renewal application, and the current license will expire on December 31st. So it may take until December 31st before this new license can be issued, but I'm sure this thing happens all the time. I'm sure the ABCC would understand it as well.
Yes, okay, thank you. So again, the application Casa Real Restaurant and Bar, Inc., DBA Casa Real Restaurant and Bar, they are applying for the same type of license that existed, a common vicular with an annual all alcoholic beverages on-premise license, as well as a entertainment license, which we will discuss in the next public hearing. As we show here in the application, they will not be doing any major renovations. It'll be a similar layout to the existing. They're going to be doing some cosmetic changes. It'll be the interior and enclosed patio space as well. I discussed with them if they were going to be asking for the extended space that was used during the pandemic. They will not. They will just be using the interior space and the extended closed patio in the back there as well. So I will put it over to their representation and any questions.
Thanks, Amy. For the record, Brian Swain, attorney for the applicant. I believe Myra Escobar is also here and potentially available if there's any operational questions. This, as Amy said, is an application for an annual all alcoholic beverages liquor license in a common vicular. We'll get to the merits of the entertainment license at the next hearing. It's being requested in connection with their Mexican Salvadorian themed restaurant. This location has historically been used as a restaurant. As Amy specifically stated earlier, unfortunately, it's sitting vacant. And I guess in furtherance of what Amy said, the applicant of the prior restaurant has surrendered it. So while we're kind of in a technical limbo with it, they're not in there, and I don't think there's any intention of them setting foot in there again. They are performing some minor renovations, nothing structural, fresh paint, replacing the furniture, the decor, updating the fixtures in connection with its specifically themed restaurant. They would like to be open ideally from 11 a.m. to 1 a.m. and Monday through Thursday, Friday through Sunday, 7 a.m. to 1 a.m. However, they did request to be open 7 a.m. to 1 a.m. 7 days a week. That being the case, if they do establish a successful breakfast service, they would like to be able to do it and not have to come back to the board for further relief. But in terms of getting off and up and running, ideally they'll be operational from 11 a.m. to 1 a.m. Monday through Thursday. There is outdoor seating that is intended to be provided seasonally that was previously licensed. It's a family-friendly restaurant. The patrons will receive table service. The menu is going to include traditional Mexican and Salvadorian themed cuisine, including tacos, carne asada, some sizzling fajitas, pupusas. The service will end at 1 a.m. as required by the town's rules and regulations. And they are applying for the same classification type and every other category of a liquor license that has previously existed at this establishment under the Salt Box and AK Diamonds. And we're very excited at this opportunity to open the restaurant, provide an additional year-round establishment, another family-friendly establishment, casual dining, and it's going to fill a much-needed cultural niche and provide an exceptional dining experience for year-round residents. Thank you.
Thank you. Amy?
Thank you. I'm just going to clarify a couple things as far as the hours of service, as we just discussed. You would be able to discuss hours between 8 a.m. and 11 a.m. If you needed to make any considerations on liquor service, you have the ability to do that, as we just discussed. And on Sunday, liquor service could not begin until 11 a.m. So per our rules and regulations on Nantucket. So just those two clarifications as far as liquor service is concerned. And then I know, Mr. Dixon, obviously, I think this is your first new license application with us. So just as I put in most of these applications, the 5 pillars for consideration in these licenses is the appropriateness of a liquor license at this location, which obviously has existed before, the number of existing dispensaries in town, we're up to 107. The views of inhabitants of the locality which a license is sought, we have not received any responses. Traffic, noise, and size, typically applying to a new location, and the sort of operation that carries the license and reputation of the applicant. This applicant has been involved in the Salvadorian market and on the island for a while, so they certainly have been established in the business community as well. So just as a reminder, those are the 5 pillars in determining this as well. So,
okay, thank you. Any board questions? Go ahead, Brooke.
So this question about when they can begin, as I understand it, the former license is active, but the license holder, I believe that lease was up in October. So that they may have a license to the end of the year, but they don't have access to the property. Does that mean these guys have to wait until December 31st? Or I would love for them to be able to get going. I know this has been a delay that they didn't expect. So,
yeah, and I think correct me if I'm wrong, Mr. Riley, but the opening for food only would be allowed. It's the service of liquor that will be determined by the ABCC, and it may be certainly after that. And the timing of ABCC review lately has been 2+ months on a lot of things. Some have been longer. So I just spoke with them about this as well. That, I can't control depending on the ABCC, and they may wait until that just to be sure. But it's likely it would take that long anyway. But food service, should they get all their inspections and approval, can certainly begin without the liquor.
Great.
We can also make a contingent on, either December 31st and it's up, or they go and get the previous owners to sign off, and put the onus on them to go get that info.
Correct. And as background, we've been certainly asking for this for the entire year. This has been a back and forth for a year, requesting this surrender or some direction from the former licensee. So it's certainly been going on for quite a while. And I didn't want to take it to any sort of contentious to revoke it unless there was some sort of fight against it. So this would be a better way to go, I feel.
Yeah, they may have more success than you had or we would have because they've got an incentive. So
yeah, we've reached out to several different areas. So correct. So we'll see how that goes.
Okay. My question is on the breakfast service during the week. Can we just allow that? Because I mean, that's a niche on Nantucket that's like sorely missing establishments. I would prefer to just allow them to have it now if they want to.
Yeah, and that's all depending on special permits, location, and that would be allowed. And I was just referring to the beginning of liquor service. Whereas if you wanted to make any sort of conditions between 8 a.m. and 11 a.m., then I wanted to clarify that Sunday they can't begin liquor service till 11 a.m.
As no one can on the island.
Right,
so,
correct. Correct. Yes.
I mean, I don't have a problem with them allowing liquor service in the morning during the week. Brooke?
So are there other establishments that serve liquor at 8 a.m.?
Mm-hmm. Yeah, a good number,
Okay.
Unless there's any sort of reason to establish it, but that's generally, they are allowed that on their licenses. I don't know how many actually do, but yes, it is allowed.
This is a public hearing. Is there anyone else here who wishes to speak on this application? Are we putting limitations on liquor service outside? Or are we feeling that that's enclosed enough? Brooke?
Was the former license holder allowed to serve liquor up to 1 a.m. In that patio?
Yes, but let me do that. I believe hold on, second factor
I'm going to
authorization.
pull it up to see if there's any.
I'm just going to double check my memory because it doesn't necessarily work well these days. But yes, and I would like to actually in the meantime ask Mr. Swain about, I know there's apartments and the applicant here is owner of the property, correct? And would be the landlord of those tenants.
Correct. They own they're separately condos, but they own the whole building that makes up the former AK Diamonds establishment and the two condos above it. So they're owner operators and owner landlords.
Okay. Because we'll talk about that in entertainment, but 1 a.m. Yeah, the second floor dining room, 2 bathrooms. License includes liquor service in the interior restaurant and the adjacent back patio. There were no restrictions. It was 8 a.m. Monday through Saturday, 11 a.m. start on Sunday, and 1 a.m.
Okay, so no change.
No change.
Okay, Brooke,
So if we're ready, I'd move to close the public hearing.
is there a second?
second,
Okay, all those in favor by roll call. Brooke Moore,
Aye.
Tom Dixon,
Aye.
Matt Fee,
aye.
John Holgate, aye. That carries unanimously. Is there a motion to approve this?
Yes,
move to
I'll move
approve.
approval. Yeah. Second.
Um,
And should we
Was-
be
was
specific
there
about
any-
including?
specific about allowing them to breakfast service during the week? And
Yes,
and
and
can
liquor
we also-
service for all allowed hours within their opening hours.
Yeah, and then
Yeah.
also if they get someone to sign off on the old license, that they can start as soon as they have ABCC approval. But they can also,
Yeah,
they can
and
open
that.
for food as soon as they have their inspections and so forth. Okay. Got it. Is there a second?
I'll second.
All those in favor by roll call? Brooke Moore?
Aye.
Tom Dixon?
Aye.
Matt Fee?
Aye.
John Holgate, aye. That carries unanimously. I have a hand up, but I had already closed the public hearing on that one, but we're going to move on to the entertainment license for the same establishment. Can I just see if Wilbert Garcia has a question or a comment?
He just needs to unmute.
Wilbert, you need to click your mute button, your unmute button to be able to talk. Okay, well, I'll move forward with letting Amy present the entertainment license.
Thank you. So we're moving on to the entertainment license. I'll just start with pre-existing license that we had here. We'll categorize it as a live entertainment license with background music and amplified live music, DJ, and others allowed as well. We had a condition on the former license, 7 days a week till 10 p.m. Licensing department must be notified in advance of any special events with live entertainment. Streaming background music only can be played indoors until 1 a.m. We get the condition of live music ending by 10 p.m. So that was pre-existing. The applicant here, Casa Real, is asking for similar. They desire to have background music in the interior and exterior patio of the premises played through the house sound system. They also have television throughout the interior of the premises, which was allowed. Live music and/or DJ services are proposed to be limited to the interior of the building. There is no plan for a dedicated dance floor or to move furniture around to create one. And I'll defer to Mr. Swain if there's anything additional in that as well. So it's similar to the last one. I think they've asked for entertainment hours till 1 a.m., which for background music is fine. And I think the board can certainly determine conditions for live entertainment music in that area as well. I'll leave it to any questions.
Sorry, may I go to Wilbert Garcia now? Oh, you're muted again. You were unmuted, now you're muted. You need to click the unmute again. Okay, continuing to have some difficulties there. Brian Swain, did you have anything to add on the entertainment?
I think Amy did a great job describing it. It's more for ambience. The way entertainment is applied for, there's different levels, and you have to apply for amplified music, but this isn't amplified in the sense that you would have at the Rose and Crown or the Chicken Box. It's just a classification to give them the ability to have live music. They'd like to have a mariachi band with reasonable hours playing in the background of their restaurant. So happy to accept the condition that it ends at 10, I think Amy said 10 p.m. And again, that's limited to indoors, and they'd be happy to limit the exterior background music to what Amy said earlier. So really not asking for anything that hasn't been there, just the ability to have a live band on the interior.
And if I may just follow up on the conditions for the previous applicant, I think there was an unknown with the applicant, and there was concern with it being separate from the residences or any abutters, that we asked for any notification of any special events that would increase the volume. So I think that's where that came from. I think 10 p.m. is a reasonable condition with noise ordinance and all of that. So that's where that came from.
Okay. Any further questions from the board? I don't see any hands raised. Is there a
Just one
motion?
question, Don. Do the same owners own all three buildings that are gonna have housing, or do they own just that one building?
It's just the one building, Matt.
Okay, and there are residents above both of the others, correct?
That's correct.
Right.
They meet regularly as a homeowners association, so if there's any issues, they'll gladly address them in-house, and Amy has her finger on the pulse of everything, so I'm sure she would hear about it anyways.
Yeah, no, I'm fine with that. This is Matt again. I'm fine with that. I just think it's important for us to think about, because you don't want, people who are at odds. But I think in this case, if they're meeting regularly, they own their one building. I'm fine, but we have to be thinking about that. Thank you.
Brooke?
John, for the reason Matt stated, I think keeping the notice on special events is probably worthwhile, just so the residents in the other buildings have a heads up if anything different from what is the normal course of operations is happening, so they can plan around it.
Okay. Is there a motion to close the public hearing?
So moved.
Is there a second?
Second.
All those in favor by roll call, Brooke Moore?
Aye.
Tom Dixon?
Aye.
Matt Fee?
Aye.
One Holgate, aye. That carries unanimously. What's the pleasure?
I'll move approval. These guys are good operators. They do a great job down the street. So I think it's awesome.
I will
there a
second
second?
heartily,
Okay, all
with
those in
that
favor by
condition of notice on special events. That's it.
special events. Okay. Brooke Moore?
Aye.
Tom Dixon?
Aye.
Matt Fee?
Aye.
One Holgate, aye. That carries unanimously 4-0. All right, that concludes that portion.
Thank you, everyone.
Thank you, Brian.
Thank you, Brian.
Thank you so much. I just want to thank all
thank
the
you.
board members. Thank you. It means a lot.
Good luck.
Thank you. Good luck.
Well,
We're
thank you.
excited.
Me too. We're getting closer. Thank you so much. Have a good day.
Thank you. Okay, next up, we have licensing and petitions for a compliance hearing. This is to address multiple violations for an annual all alcoholic beverages restaurant license for Mingo Corporation, DBA The Muse, Michael O'Reilly, manager, for premises located at 44 Surfside Road. I know Michael O'Reilly and Jim Mearberg are here. Who's going to start this? Okay.
And can we just this is not a public hearing, correct?
It is,
Aye.
it is for the public can view, the meeting. However, there is no public comment taking during this. We have included as well, if we need to review the, compliance hearing regulations through KP Law, and Mr. Riley is here as well to advise. But yeah, no public comment is taken during these hearings. Okay, so let me kind of gather myself here and go over this. So we are here to discuss a general disciplinary hearing for Mingo Corporation LLC, DBA The Muse at 44 Surfside Road. Several incidents, as I have included in the packet here, and some police reports that occurred over the summer. What I like to do is, after speaking with Chief Pittman and others, as far as this hearing is concerned, to focus the attention on the report 23-005831 for an incident that occurred at the location the night of from July 8th into July the 9th. As I mentioned here in the AIS, that the goal of the hearing was to review and discuss what we have identified as a pattern of behavior at the Muse through these incidents, and what steps the licensee here, Mr. O'Reilly, is taking to address these, and other incidents that have come in the past year, which I included to show that, it wasn't just one. However, give the opportunity for the licensee to discuss the steps they've taken. Now, as we've included the rules and regulations for town of Nantucket and the procedures in these cases. Generally, I know when we have compliance hearing, there is a hearing within a quick period of time. I'd like to say in this case, as we go through the narrative a bit, first came to our attention not through a call for service, but through an anonymous tip and video on July the 12th. When this came to our attention, we did notify the town administration and a select board member that actually was here at the time. It was my decision to hold on any disciplinary hearing while the police investigation was completed, because one needed to happen through this video and what happened. That was my decision to do that until they were able to fully investigate and bring charges if necessary, which happened recently. So I wanted to make that statement as well as far as the time. And I also knew the licensee was dealing with this, and we had spoken in that meantime as well. So that is one part of the incident here. I'm going to follow up here as well as we focus on this incident. I'll just briefly go over the narrative here as we've included. This is in regard to a video that was widely distributed eventually online that was taken and that was brought to NPD by a person not who took the video, by someone who wanted to remain anonymous. That video was brought here on July the 12th, as stated in the report. The video itself, again, which was posted online, showed Muse bouncers, or purported to show Muse bouncers using excessive force on patrons in the video. I will briefly outline some of the description in here as well. And I believe if anyone has not seen this video, and again, Mr. Riley, if I do anything or say anything, you need to step in for me, please, as well. Okay. So the video, again, which I believe everyone here has viewed, begins with a male patron. Again, all names have been redacted per records law in this case. On the ground, multiple people piled on top of him. The video begins, a security member, redacted, walks over, kicks the individual on the ground in the head and neck area 4 separate times. It appears as though the redacted was wearing the black shoes and sneakers at the time. While this happened, another member of the security team, later identified as redacted, was on top of the individual on the ground with his knees straddling the torso area. Another man, later identified again redacted, was attempting to pull them off. A third member of security was trying to pull him back. After seeing this kick, again redacted, grabbed another individual from behind, pulling him before falling to the ground. He proceeded to kick him in the chest. After being kicked, get up, throws a punch, but misses. Again, this goes on, the fight going back and forth through these individuals, in which time they eventually leave the area of the video. The report goes on as far as what the investigation took place, meeting with the Muse and the individuals involved in the video. Couple things I wanted to say about this. Number one, what I think is important for us to discuss is to not, what I put in the AIS, litigate the exact details of this incident, meaning it's still going through the legal process. There's an arraignment hearing in December. It's not for the board to determine who was right, who was wrong. It's about the incident itself and the actions of the licensee following this type of action. One thing I'll pull out here from this report, again, later on, explaining that it happened so fast and they did not have time to call the police like they should have. He was asked why the police were not called after the incident occurred. The individual stated that the incident happened. All the involved parties immediately left the area. It was at this time they felt it not necessary for police involvement. That right there is issue number one that we've highlighted, that in any case of this type of activity, that the police should be notified and called in that incident. And the fact that it was not and brought to us in this manner was one of the most concerning parts of this. I'll say that I've been certainly following up on licensing boards throughout the state, and Boston in particular. Any sort of activity like this is brought in to discuss any sort of activity allowed on this. Just as you have to protect the public health with food and other types of services, it's the responsibility of the licensing board and licensing authority to protect public safety in these incidents. And we did not have the opportunity to respond at the time of this, and that is one of the main complaints. I also highlighted in here that an individual came in for questioning, explained that his injuries did occur during that incident while being kicked. So in our initial AIS here that I outlined, one of the things that we did highlight was that, let me just quickly find my place here. And the things that we highlighted here. That there was a lack of staff training, that there was injury involved by these actions. We have recommended some steps here. And again, we can go over this in detail after the licensee speaks, as far as the guidelines in our regulations, which are guidelines, and the select board can certainly amend as they see fit in this circumstance. We discussed this with the licensee as far as a recommended suspension of 5 days of the liquor license, with 5 additional days held in abeyance, which we do often pending any further violations in the next year. So again, we can discuss that as we move forward, as far as what any sanctions are against this licensee. So I will say that before handing over to the licensee, that we've spoken multiple times. They have taken steps to address this, and I'll let them kind of go over what those are. So I will step back for now and let you go on to the licensee, and I can come back for any questions.
Okay. Do I need to swear in for this? I'm looking at the procedure.
I would recommend that, yes.
Okay. What do I say exactly?
Just that anyone, Mr. O'Reilly in particular, I guess, anyone who's going to offer testimony before the board swears to tell the truth, the whole truth, and nothing but the truth.
Nothing but the truth. Okay, so anyone who intends to testify today, could you please raise your hand?
I'm going to raise my hand as well because I have some direct information concerning the criminal matter.
Okay, and is there anyone who's an attendee that intends to? Well, I guess it's not a public hearing, so there's no one else who intends to speak on this.
Well, Lieutenant Mack.
Are there any other officers that will be speaking?
Lieutenant Mack is here.
Okay. Okay, Lieutenant Mack, would you mind turning your camera on? If you could raise your hand, thanks. Do you, in giving testimony today, do you all swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Do.
Okay, thank you. Let the record show that Amy Baxter, James Merberg, Michael O'Reilly, and Lieutenant Daniel Mack have been sworn in.
We're ready to proceed if you are, Madam.
Okay, if you could, Mr. Merberg, go ahead.
Okay, thank you. Members of the select board and Detective Mack as well. First of all, I don't think I've met you before, but I just want to introduce myself. My name is James Merberg. I'm an attorney. I practice in Boston as well as here on Nantucket. There are a bunch of things that I'd like to talk to you about just as a preliminary matter. The first is, just so we're very clear, this is, in my view, not something that we're antagonistic about in any form. I know that the licensing officer, Ms. Baxter, has said several times that my client is fully cooperative, and we are totally committed to doing the right thing here with regard to the operation of the Muse. I'd also note parenthetically that Mr. O'Reilly has been operating the Muse for the past 30 years. Now, in this particular situation, there were two things raised, and I want to sort of maybe get rid of the least important one first. Initially, there was an issue about whether or not underage people were going to this establishment. So we have a number of things we can report. The one report that was filed apparently had to do with some unrelated third party questioning the or challenging the activity of the officers who were outside, police officers outside checking IDs. That is not something that the Muse was responsible for. It was simply an individual who inserted herself in the questioning process of the police department. I know you've seen the reports. Was trying to counsel to outside people trying to gain admission to the Muse when the police arrived by telling them don't answer any questions. Again, I don't think that was respectfully the responsibility of the Muse. They can't control what patrons say to other patrons, or at least people who are intending to gain admission. I would also note that none of these individuals were in the Muse. They were trying to get in. We have a scanner that's been used that does scan these licenses. Unfortunately, the quality of these so-called phony licenses, and we have are just beyond the abilities of the present equipment. There is a publication called the ID Checking Guide. I don't know if each of you can see it, but it publishes on a monthly basis and includes a description of the various states in terms of what to look for in licenses with holograms and how they can be identified. What we have done, this issue is, there's a company called ID Sciences, which has a much more sophisticated scanner. The cost is approximately $4,000 to actually put these licenses in, and they claim, ID Science does, that is, that for this $4,000 scanner, it will tell if there are people who are underage. So we are committed in terms of the ID issue to not only continue to use the ID Guide, which does the updates, but also to get this particular device, which is about $4,000, which they claim in their literature, I spoke to the general manager earlier, that they can detect even the best inappropriate licenses, which is, I think most of the individuals who are on this Zoom call know, and certainly Detective Mack knows, excuse me, these devices and these licenses, excuse me, are so good that they routinely fool people. But we do have a better license now than we had, a better device, excuse me, than we had before. Now, with regard to events, the reason I raised my hand is because I was involved in the show cause hearings with Detective Mack and others, Keith Mansfield. There were 3 individuals who were the original subject of that investigation. One of the individuals, after a hearing, was not charged with these offenses. 2 individuals were. 2 individuals that were charged with assault and battery have both been discharged by the Muse. They are no longer employees of the Muse. When we talk about at least the initial remedial steps, both of the individuals who are depicted, of the 3 individuals who have security names on their shirts, they have already been discharged from employment. Now, just as a sidebar, and I understand this issue is not to focus on the events of that day, the select board should know that it is likely that the other participants in this event, which resulted in the charges against the 2 individuals that work for the Muse, are likely to be charged as well. There will be additional show cause hearings charging the individuals who claim to have been assaulted and who are depicted on the video being charged themselves with assault and battery. But again, without getting too deep into the woods on the issues of the assault and battery case, I would simply say that a number of people has a policy in effect which requires them a number of things. Each manager has been and will continue to be subject to the crowd manager regulations and training program. Each manager, and there are 4, has been through the crowd manager regulations and training program, which is required in Massachusetts. Everyone who serves alcohol in the establishment has been TIPS trained as required. The Muse has also put together a procedural book, and I believe Amy Baxter may have a copy of this document. I don't know if it was submitted or not, but it's a detailed protocol that requires each person who's engaged in security to understand what the protocol is. Now, addressing the issue at hand with regard to what occurred, there was an altercation inside, and I again would note, and I think the collective experience of the board will understand this. When you mix alcohol and young men and women and music together, that sometimes is unfortunately a recipe for some interactions. From reading the reports, and I have the unredacted reports because I was involved in the other matter, it appears the genesis of this was two different ethnic groups having an argument inside the Muse, which started over some dispute about whether one group of individuals should talk to another group of individuals who had some female accompaniment, female members with them. It resulted in a spilled drink. There was a very brief altercation, and the training was and is that if there's an altercation, separate the parties, exclude them from their premises, and then have them leave by separate entrances. In this case, there was a Hispanic group that was taken out the front door. There was a group of people from Georgia, country of Georgians from near the Ukraine. They were taken out the back door. That ended what the Muse thought was this altercation, which took place on the dance floor. Unfortunately, the parties reunited in front of the Muse and started again to engage with one another. That's when the bouncers came out. That's where you see an abbreviated portion of the video, where in part, of course, there's about a minute and a half where there's an altercation. Now, in this particular event, we understand that perhaps in hindsight, maybe not even in hindsight, upon due reflection, the police should have been called. The principal problem was it only lasted about a minute and a half, and the participants involved, all of whom were at the time unknown, dispersed. So if we had called the police, it perhaps should have, the only thing we could have reported was there was an altercation inside, the parties were excluded, they were separated, left by different entrances, and then they somehow reconnected somewhere near the front portion of the premises outside and started up to engage again, which has brought the security out. By the time the police would have been called, had they, and perhaps should have been called, the parties had dispersed to parts unknown. They wouldn't have been able to give any information as to who these individuals were or what their names were, or what happened. Now, I indicated earlier, they have already dismissed the two individuals who were involved in this altercation, who have been charged with a pending matter in the district court. All the police has been now burned into the memory of every staff person who still works for the Muse. They intend to call on every occasion. The Muse is not interested in fostering any kind of hostile environment for anybody on the premises at any time, under any circumstances. I'd also note again, sort of as a sidebar, post-COVID, the Muse has struggled since the publication of the Nantucket Current articles. Their business has fallen off even more dramatically than it did, at least initially, when COVID-19 struck. So the Muse is very interested in complying. They're very interested in surviving in this environment, and they're very interested in conforming themselves to make sure that the select board understands they're trying to do the right thing at all. At this point, what I can say is, in hindsight, yes.
When you turn that way, we lose
my apologies.
You.
Yeah, I'm on a line.
Directly into the mic.
I'm
Thanks.
sorry, my apologies. I was looking at my notes. I apologize. You get to be my age, you have to look at notes occasionally.
No problem.
So again, what we've done is literally everything that we're able to do to try to remedy this problem. Again, recognizing that in this environment, we have a number of Spanish customers. They like to dance, they like to use alcohol. We understand they shouldn't be overserved, and we do everything possible to avoid it. But just the combination of young adolescent men, women, music, alcohol, from time to time, events take place. We have tried as assiduously as one can to avoid people confronting each other. We toss people out on a regular basis that do anything inappropriate. We even have a protocol where the DJ will periodically tell people, Here's where the exits are. Don't drink and drive. Don't use too much alcohol. Enjoy yourself. Have fun. Be friendly to one another. And they make these public announcements literally during the course of the evening over and over. With regard to additional steps to be taken, we have tried to tighten up the protocol so that every person involved in security, and there's always a full-time manager on. There was this night, particularly this night was Mr. Thompson, who's one of the individuals who's been fired or let go. I shouldn't say fired, terminated. You know, we're trying everything we can to do the right thing. And I think Ms. Baxter in the original comments had said to the press or someone that Mr. O'Reilly is fully compliant, done everything he can do to try to make this right. We also, by the way, have ordered some additional surveillance cameras over and above the ones that should have been operable that night in front of the Muse. We're trying to do absolutely everything that can be done. The Muse has sort of a niche business. It caters to, as I say, Spanish and other minorities. There aren't many places on this island where some of these minorities feel comfortable and at home. And we're doing everything we can to balance whatever ethnic issues there are between various people who participate in their nightclub activities there. But what I would say it's sort of at the end of all this is I understand the recommendation made to 5-day suspension, 5 days suspended. What we're asking for is there to be no suspension, even if it's a 10-day sword of Damocles, because this operation has done a very good job of trying to do the right thing. You know, again, admittedly, calling the police probably would have solved this problem that night. I'm not sure the police would have been able to do anything. And again, in terms of cooperation, even the 2 bouncers who have been charged, and I don't know if Ms. Baxter knows this or not, she may, they actually went to the police department and gave voluntary statements after being advised of their Miranda rights. And in the unredacted police report, which I indicated I do have, they've come in on their own voluntarily and gave full statements trying to explain what occurred that night, including the fact that it happened quickly and the parties dispersed. So although the bouncers may have acted arguably, at least from the board's view, inappropriately, they tried to do the right thing and tried to cooperate and believe that they were the individuals who were the victims, not the attackers. As I say, ultimately, that issue may get vetted when their show cause hearing comes up for the applicants who may be applying for charges against the 2 individuals who claimed that they were assaulted. So, you know, it's an unpleasant event. But again, I think in terms of management, everything that can be done was done, will be done, and they're committed to taking any recommendations the board thinks is appropriate. The only thing we're asking is that you exercise your discretion, not suspend this business, particularly in these economic times when they have already had a fair share of difficulties post-COVID, and now because of the adverse publicity. We're happy to answer questions. Mr. O'Reilly is happy to answer any questions.
Amy?
Thank you so much. I just wanted to respond to a couple things. Yes, Mr. O'Reilly has been compliant. We've talked, and they've taken a lot of steps and recognized that things needed to be done, and we appreciate that. I'll back up real quick to the mention of underage issues that we had, and I did include some reports that happened around the same time this did to show that there were several things that kind of came up that we received information that people were concerned that there were underage people in there. That's why there was a response. However, legally, you know, it wasn't a compliance check. We can't legally say that that's what was happening. It was an incident. It was just showing some sort of pattern that we were dealing with this summer. So I am not focusing on that so much as this one incident. I will say that yes, police might not have been able to stop it. However, people come back. If there's something of this that happens that needs to be reported, or we need to have that. If we hadn't had this video, would we have known? Possibly not. We've gotten a lot of feedback from people in the community wanting to see that something does happen here, that we do take some action here because of these activities. Yes, they've done a great job of responding and working on how this works out better. But I think we need to look at what happened here. You know, I'm afraid if there's smoke, there's fire. What else is happening, and making sure that we do respond to this incident, that Police were not called, that there was not a manager that seemed to be directing those activities or handling it. I will say that, yes, they did come in after, but after we got this video and after that was brought to our attention. So there's concern there of this type of activity, unsafe environment of a place that you are licensing. So I think there does need to be some sort of suspension. Again, it is at the discretion of the board. I'll say historically, when we've had issues or we have compliance checks and there is some sort of violation, historically what we've done is applied that suspension to the same date the following season when that incident occurred. So this would be in a July timeframe, and absolutely to have some days held in abeyance should things still be a problem. So that is at the discretion of the board. So I believe and then everything, yes, Mr. Merberger said that has been done. I submitted as well the employee manual that they also came up with, and they have followed through with all those other items as well. So just to say that we do think there needs to be some sort of action taking on this incident. Thank you.
If I could just respond briefly. Again,
Yes, go ahead.
I think we're all on the same page about safety and about everything else that has been discussed. The problem is this really smacks of a punishment for an operator who's trying to make a living in a community where he provides a service to a certain clientele. I don't think suspending in July or suspending at all is necessary. This hearing is probably more than sufficient to alert everybody, including the community, if anyone is watching this, that steps have been taken. People who perhaps were not trained sufficiently have been replaced now by people who are. So I'm not sure that a punishment, and which is really what it would be, because that's the busy season. Obviously, we all know that the summertime is when the Muse earns most of their revenue. Is really going to be, I don't want to say it's mean-spirited, but I think it's under the circumstances with an operator who's been involved for 30 years running the place, has learned from this experience, but doesn't need to learn and suffer financially for 5 days in the middle of the summer. If it was 5 days in February, maybe it would make less of an impact financially and keep my client, who has at various times between 20 and 50 employees, able to stay in business. It's obviously they're in the slow season or coming to the slow season now, where they're going to be down to perhaps 20 employees. But to take the penalties suggested, I think is perhaps maybe an overreaction to what actually occurred. It's a singular event we're focused on. I think the licensing individual has agreed that there's no evidence of underage service, and there's certainly every effort to comply not only with scanners but every other protocol that's possible. So I'm going to ask the board, I know Ms. Baxter and respect her, to disregard her recommendation and not impose the kind of sanction that would be crippling for my client, particularly next summer. It's one thing if you come in fighting and arguing. It's another thing if you come and say, we'll try to do everything we can do, which is, as I hear Ms. Baxter say, we've done. And I don't think that the suspension is necessary as some extra penalty for someone who's always tried to comply. And I'm going to ask you respectfully not to impose the recommendation, Ms. Baxter. And again, Ms. Baxter, I have great respect for you. I just don't think in this case it's necessary to impose a sanction. Thank you. I don't know if the board wants to hear from Mr. O'Reilly directly, but I'm happy to let him speak if you have questions.
Just so we know, Brooke Moore had to leave, so it's the three of us, Matt and Tom. Okay. Do either of you have any questions or comments?
Yes, Madam Chair, through you to Amy. Amy, the suspension being, as you said before, in the same month when the violation occurred, that is precedent. That is standard protocol. Am I correct?
That's correct. And yeah, it is hard and it's tough. But that's when our season is, we do it in January. It doesn't have an effect, and it's meant to have an effect. Depending on what you take as the seriousness of what occurred, even though there's mitigating circumstances and they have done a lot to address it, absolutely. But we look at it as, okay, there needs to be some sort of consequence for this type of activity. And whether it's less than I did do the ceiling, I didn't tend to give you room to work with it and what you feel is best. Certainly it can be less than what I recommended, but I think it's looking at what happened here. And if we do nothing, saying to other folks, well, hey, if they can do that, then one or two other things can happen and nothing's going to happen. So I think it's just important to kind of take that into consideration. But yes, that is precedence that we put any suspension on the same date the following year.
Now, we could do a lesser suspension and hold days in abeyance, where if there was another incident, those would go into effect.
Correct. Absolutely. It's at your discretion.
Matt?
Yeah, and that's where I'm leaning, is to do 1 and 9, 2 and 8, hold a bunch of them, in abeyance. I think we need to do something, but I don't know if we need to do a full 5, especially because of the date. The 9th and the 10th, I think, is a Tuesday, Wednesday this year. I think this was, if I've got the dates right, I think this was maybe it's a Monday, Tuesday. This was a Sunday, I think. So, and I know that's a big night out there for my employees. And so, if we did it on the same date, it's a Monday or a Tuesday, but that would be my sense. Just in general, I do, and I'm not saying anything about underage here, but I am saying we should talk about the policy of, like, when we sting, we have to sting everybody. We all end up knowing very quickly. We kind of know where the kids are targeting, and those are the places that need the attention. Not every single license on the island, and so I think at some point that should be a discussion we make. That's not for today, but if we want to get this type of thing into control, not the fighting, but the other stuff that's happening, then I think that we need to work, the police and the different people need to work together so that the young people know, especially the places that they're targeting every year. A couple of years ago, Amy and I drove up and the kids would scurry like rats. We know where they are. So anyway, that's a topic for another night. But I could see us doing 1 and 9, 2 and 8. I welcome what other people are thinking.
Okay, this is a compliance hearing. It's not a public hearing. So do we need a motion to close the hearing or no?
You can.
Okay, are we ready to close the hearing, or does the board want to hear from anyone further? Brian Riley, did I interrupt you?
No, I was just going to say, if you've heard from the participants and just want to limit it to the board discussing what to do next, I would recommend a motion to close the hearing.
Before we close it, I have a question for Michael. Did you have you had a lot of protocol, employee manual? Was that in place this summer, or is a lot of that new?
There's a new manual that we submitted to Amy, and I believe she showed everybody on the board. It was just in addition, on top, in light of everything that happened, just to reinforce our direction and where we're going and policies.
Yeah, because I will say that was fairly complete, and makes me happy I don't deal with liquor. I can tell you that, looking at it, but.
Okay, do you want to move to close the hearing if you're satisfied? Anyone?
So
Okay.
moved.
Matt?
Second.
All those in favor by roll call: Tom Dixon,
Aye.
Matt Fee,
Aye.
John Holgate, aye. That hearing is unanimously closed 3-0. Now, board discussion for what we want to do. Does anybody want to throw out an idea?
Well, for discussion, I'll say we do 1 night and 9 in abeyance, and make it on the 9th.
Okay. Tom, thoughts?
Was 9 the right date? Do I have the right date, Dawn?
That's what I was looking back for.
I'm just doing it off my top of my brain.
Sorry, what was the? Oh, I'm going back to the wrong thing.
If it helps the board, it was July 9th.
All right, yeah, so, all right, thanks.
What day does that fall on next year? Let's just double check that.
It's on a
It's a
Tuesday.
Tuesday.
Yeah, it's a Tuesday.
I mean, I was kind of, I was thinking of a 1-night suspension and 4 in advance, but.
Madam Chair, if my colleagues are thinking 1 night, then I would maybe say the 5 in abeyance, 1 and 5.
1 and 5. Matt, would you be?
I'll second that.
Okay. Any further discussion? Okay, so we are voting on a 1-night suspension on July 9th of 2024 with 4 days held in abeyance if there is an incident.
I thought Tom said
No,
5 days.
5 in abeyance.
Oh, no, I'm sorry, 5. So 6 total, essentially. And that runs, the abeyance runs for a year. Is that right? Okay.
Have it run for 1 year.
If there was another incident, that additional 5 days would be imposed.
Right. And those are substantial. Those would pick up, if they're imposed, those will pick up a weekend. It'll be a Wednesday through a weekend. None of us, no business wants to do, wants that. This is giving plenty of incentive for, this not to happen again. If something does happen, because, to call the police and get people there right away, they want to do the right thing. They've got tons of motivation to do the right thing here. So I feel comfortable with that.
Okay. All right, we'll go to a vote. All those in favor by roll call: Matt Fee.
Aye.
Tom Dixon.
Aye.
Tom Holgate, aye. That carries unanimously. So thank you.
Thank you for your help, Madam Selectman.
Thank you.
Thank you. Okay, we have one final item on our agenda. This is just about future hearings.
Thank you. I'm just going to, if I can just briefly say, I didn't have a chance to do a nice slide for you, but what I wanted to just say briefly to you, again, thank you for your time. It's much appreciated. I think it's a matter that deserves, focused attention. So I appreciate that. Listening to your last conversation about establishing this meeting, there's a couple things really that didn't get said in that. Our intention here is to help you be better informed in the decisions you make. You're not necessarily seeing the full picture, just dealing with these full-time liquor licenses. If I look back at our annual report here on what we issued 115 one-day liquor licenses last year, and probably 50 different special event permits, beach permits, and other things that are being done administratively that should be really put before a licensing board. These aren't public hearings necessarily, but it's something that you should be informed of and understand what is being issued in the name of a licensing board. Also, I think it'd be helpful in each of these meetings for you to have a report of the previous month for calls for service or any issues that I'm seeing as well in email. So that should we come to these types of hearings, we have a history and that you have been, informed and having this meeting hopefully will be helpful for that. So I just want to touch on that and what we hope to provide for you. And again, appreciate your time. So that's it.
Okay.
Okay. Great.
I mean, I think that this went well for her first one.
Yes.
And I definitely like doing this at a separate meeting.
Yes,
And
I appreciate it.
Add in utility petitions. I mean, we won't have compliance hearings very often. The other things didn't take very long.
Right. And hopefully we can make efficient use of your time. And this way you have a better picture of the full picture for when you're making these decisions. So we'll hopefully make an efficient use of your time moving forward. So we appreciate it.
Okay, is there a motion to adjourn?
So moved.
Second.
All those in favor? Matt Fee,
Aye.
Tom Dixon,
Aye.
Tom Holgate, aye. That carries unanimously.
Thank you.
Thank you all.
Okay, nice to see you all.
Thanks a lot. Bye.